Welcome to Dad Talk Today. The podcast for dads facing some of the toughest moments of their lives. We are here to walk with men through divorce, keep them connected to their kids, help them understand their rights, and work for change in family law courts. Moms, you are always welcome too. We are all about advocating for shared parenting and doing what is best for our kids. Here is your host, Eric Carroll.
Hey everybody, welcome back to Dad Talk Today. It's Wednesday night. We usually do this on Monday, but it was Memorial Day this past week. I hope everybody had a good, safe holiday. Kevin, how was your holiday?
It was great, man. Did some cooking outside, and we ended up with some pretty good weather. So, yeah, I had a good holiday. How about you?
It was all right, man. Got to see some family and friends. It was really good. Did some grilling out. Man, I see you seem like a little bit of a chef of some sorts as well, man. You're really into cooking?
I love to cook too. You know, after a week of working and stuff on the weekends, I like to cook. So that's kind of to get my mind off things.
Yeah, I understand that perfectly. Well, guys, if you have any questions for Kevin, put them down in the comments and I will bring them to him. Nothing about this creates a client-attorney relationship. Kevin practices out of the state of Arkansas. A lot of this is very similar to other states, so we'll give you advice as best as we can, but it's not to be taken as professional legal advice, even though you're talking to a professional. Now that I got that out of the way, Kevin, we was talking about some of the things, like some of the misconceptions and different stuff, especially billing. Billing seems to be like one of the number one things people have a problem with and sometimes don't understand. Could you talk to me somewhat about the billing process?
Yes, and you need to be, and I know it's hard. We talk about a lot of times people, when they go in to talk with an attorney, they are nervous about it, or they feel a little intimidated because an attorney is a professional, and sometimes they're not real open about things. But you need to ask questions about your billing, your contract, how you're going to be billed by the attorney, so that you're very clear on what you're paying for. An attorney's not going to have an issue with you asking questions about that. We want to know up front if you've got questions, as opposed to down the road when you've got issues with your bill or whatever, and you have miscommunication about what the bill's about. So we have a one-page contract on the vast majority of our cases, and it just explains what our retainer is and what the billing rate's going to be. And it's pretty straightforward as to what we're going to be doing as far as your bill. Now, when you hear the word retainer, a lot of people don't know what that means, and it's different for every attorney. The vast majority of times what that means is that you're paying for several hours of work in advance. It's kind of like a lot of contractors that do contracting work. They want half up front or something like that. It's very similar to that. So for instance, our office will usually charge a retainer, and then that's a credit on your bill basically. And so then I start billing my time anytime I spend time on your case, and that will be paid out of that retainer. And you won't owe anything else until that retainer is extinguished. And then a lot of times we'll ask you to either pay another retainer, or you'll have to start paying your bill in full each month. So if an attorney's asking you for a retainer, make sure you understand exactly what that means and that's how it's going to be used. You know, one of the misconceptions is on time and billing time. And a lot of clients get upset. We'll get a question, hey, you billed me for reading that email. I didn't know that. I wouldn't have sent you an email or whatever. You need to assume that anytime you send your attorney something that you're going to get billed for it, or anytime you talk to them on the phone for 10 or 15 minutes, you're going to get billed for it. And if you wonder whether your attorney is going to bill you for that, just ask them. But Abraham Lincoln had a great quote back in the day. He was an attorney, and he said, a lawyer's time is their stock in trade. That's the product we have is our time. And so that's what we bill for. And, but anytime you have questions about your bill, just ask your attorney.
You know, and I know there's a lot of, you know, I don't want to say a lot, but there's definitely some good attorneys that we have here on the show and we talk to. And some of the things I've kind of seen from an attorney's perspective that I don't think we see as much is you guys having to get familiar with someone's case, especially one that's been going on for years and years and has mounds and mounds of paperwork. there's no way to operate a practice or anything without charging. And that's what a business is,
That's true. And the client's been living their case. We haven't. I have to try to get into the client's shoes when I'm taking over a case. And if you've had problems with this person or the lawsuit, whatever it is that's been going on for 1 year, 2 years, 3 years, there's a lot of information there. There could be hundreds and thousands of text messages, emails, voicemails, pictures, Snapchat stuff, Facebook stuff. As your attorney, you're going to want me to go through all that. You're going to want my paralegal to know about that stuff or help me with that, because the more we know about your case, the more we're going to be able to help you, and that takes time. And so just understand, if you have a lot of information, that's going to take a lot of time to go through. And one of the best things you can do for your attorney is do legwork. Ask your attorney, what can I do? Can I go to the courthouse and pick something up, or can I go do this or do that? Can I put a binder together for you that has a timeline? That's one of the best things that I ever get from a client, is a binder full of information with a timeline telling me what's going on. That saves so much time and saves you a lot in attorney's fees.
That was something I was going to pick your head about. What are some other things that people can do to kind of keep down on that attorney time, so when they come to you, it's a little bit easier for you to kind of jump straight into that case rather than having to spend weeks to get familiar with it?
Well, just think about what would be the easiest way for you. If I came to you and needed to tell you my story of the last 2.5 years, instead of throwing all this stuff to you or putting it all out there unorganized, what would be the easiest way for you to understand it? And think about it that way. Well, that's going to be the same way it's easiest for your attorney to understand it. So if you can put a timeline together, just type it up, an Excel spreadsheet, or just type it up on a Word document, and have a binder that says, when I told you on September 15th in my timeline about this text that she sent me that said blah, 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 it's on page 7 of the binder. And you can see it there, exactly what was said. When you can put things together in that way, for me, that is incredibly helpful. And it saves hours upon hours of time.
There you go. We got one from Larchmont, Martinique. He said, not sure if I put this in the wrong place. You actually put it in the right place. And for anybody that's watching this, if you'll put your question down in the comments, I will bring him to Kevin. He said, what if the baby's mom and stepdad teach a 19-month-old to call the stepdad favorite daddy? Is that the beginning of alienation? Side note, the mom has borderline personality disorder.
That's an excellent question. And this comes up a pretty fair amount of time. Many times you have new people in a relationship, either a stepfather or stepmother, and the child, especially a young child like this, is going to look at every adult as some kind of authority figure and assume that an adult in the home is going to be either a mom or a dad, and may start calling them those kinds of names. Judges treat that all very differently. Saying favorite daddy, if I were a judge, I would have a concern about that. Most judges that I'm in front of are very protective of the father and the mother, and making sure that the mother will correct a child and make sure that they understand this is not dad. Dad is, that's your father. I'm your mother. Dad is your father. If you want to call your stepdad either stepdad or by his name, or call him Daddy Bill, or whatever his name is, that's usually okay. But judges are usually pretty protective, in my experience, of parents, the actual mother and father, and making sure that the child knows who is who. So is it the beginning of alienation? It sure can be. That can be one of those initial steps that leads down that road.
That's probably one of the steps that's not discussed as much. I think there's different angles to alienation. I know we talk about the brainwashing of a child, but there's many different techniques that are used. What are some of the other techniques that you have seen an alienator use in these cases, Kevin, to turn that child against the non-custodial parent?
Well, it can be very subtle, like picking a name like favorite daddy or something like that. We always talk about refusing visitation, or, well, she's sick this weekend, so you can't get her. This last year, what do you think the number one excuse was for canceling visitation? It was COVID-19. Oh, we've been exposed, or we might have been exposed. And that would go on for weeks. and I really applaud the Arkansas Supreme Court, and I think other states did it as well. They came out fairly quickly and said, you're not going to use COVID as a reason for not exercising visitation. If the child has actually tested positive at your house, then there may be a quarantine situation we would look at. But if they were just exposed and they're not showing symptoms, they have just as much right to be at the other parent's house as they do at your house. So that was one of the big alienating tools of the last year.
How much do you see an increase around the holiday times? It seems, especially around like Christmas and Thanksgiving, is when we really see these things start to skyrocket, because by that time, most of the time attorneys are at home spending, time with their families, and there's not much you can do.
It can be. People will talk earlier in the year, weeks and months ahead of time, and make plans for particular times for Christmas or Thanksgiving or whatever. And then the other parent will either forget that or never got the text, or they thought there wasn't an agreement and there was. And then they make plans, and then you have a problem. And, sometimes it's intentional and sometimes it's not. But holidays can be a big issue.
Yep. Diego Gomez said, I'm currently going through a legitimation process, and the mother decided to hire an attorney as well. One of her petition requests is that I cannot introduce our daughter to a girlfriend or be around my girlfriend while with my daughter until after 1 year of the legitimation. Will the judge grant her this petition?
That's a good question, and I don't know if she's remarried, but if he does, you can request that the same apply to her, that if she brings any new person like that into the situation, that she has to play by the same rules. Many times one parent will want the other parent to date someone for a certain amount of time before they're introduced to the child. A lot of times we put that in agreements. When we've got a divorce situation or a custody situation, we'll negotiate that and both sides will agree on it. Judges are careful about that, and they don't want children around a new significant other every few weeks. So a 1 year, I don't know if that's too long or not. It just depends on that judge. That seems like a long time to me. The biggest thing that judges get super concerned about, in addition to multiple people being around the child, is overnights. They definitely don't want someone that you're romantically involved with staying overnight unless you're married. They usually frown on that, unless it's been a really lengthy relationship.
Yeah, he said she is not remarried, but I trust her judgment is she decides to start dating.
Well, then, she, one of the things, the question that he asked, I guess, was really after he had been legitimized for a year. A lot of times what's put in there is that the person's been dating someone else for a certain amount of time, either a few months or several months or a year. So I see that now, kind of that's what he's asking about. I think if you've got a situation like that where you're waiting for a length of time for the relationship, that should go both ways.
Yeah, I mean, I could be wrong on this, Kevin, but I think this is probably a very big concern, especially in newly divorced people. If there was an affair or something going on, not just that. I mean, it could be any time you see your ex-partner, someone you once loved, with someone new, and then your children's there. There's a lot of emotions that come along with that, especially if they get remarried. Sometimes they're seeing your children more than you are. I think time is a powerful healing tool. Definitely. It really is. And the more that you guys can get along, and I know that's not all the time, man, but the more that you can try to speed that process up, I'll be praying for you. That's definitely a hard process, but I think that would be kind of a normal question, wouldn't it?
It is. And everybody needs to know these things. You can put these plans together. Nothing's ever going to be 100% perfect. There's going to be something that he does, your ex does, that really bothers you, that is a one-time thing, and it's just gonna have to be water under the bridge. You have to let it go, and it's gonna be vice versa. Little things like that are gonna happen. Don't just go straight to an attorney or back to court with the first little thing that happens. There's gonna be bumps along the road, but you just have to try to work through those things.
Right. Lisa Brink Brees Link said, "Are there really performance bid bonds happening behind the scenes? Why is family court so deceptive? It does nothing but hinder the family dynamic, not preserve it." You might have to educate me on that, Kevin. Do you know what performance bid bonds are?
I was going to ask you that.
Okay.
I don't know what. I don't know what that is. I can't answer that.
Yeah, if you could, Lisa, kind of clarify that for us down in the comments, and we'll definitely bring it up and we'll talk about it. AJ Powell was wanting to know what part of Arkansas that you are working in, Kevin.
Our main office is in Fort Smith, Arkansas. We also have an office in Northwest Arkansas in Rogers. We take cases all over the state of Arkansas, and then of course, any high conflict custody cases, I take those anywhere in the country. So.
iTumblers on YouTube said, "Dad, talk today. My ex was caught stalking and harassing me on camera. I got a TPO and it was dismissed. She was warned that she'll be arrested for criminal trespass next time. Why are women so protected?" And I'll pull that back up, Kevin. He put a second part. Said, "This was multiple instances, by the way, not just one instance, showing up to my house unannounced, constant calling, etc."
Well, you got the TPO and then it was dismissed. We may have talked about this before. Many times when you file for, it's like a restraining order is what that is. Many times when you file for one of those, it's automatically granted in what's called ex parte fashion, which means the other party wasn't there to give their side of things. So the judges will sign it just to kind of keep the peace. They'll set it for a hearing fairly quickly within a few weeks, and then they'll decide if they're going to keep it in place or not. So I'm guessing his was initially an ex parte and then it was dismissed. I know it sounds sexist, but many times women do seem to be, and the research shows this, more protected in these situations than men do. Men can be just as abused, if not worse, than women. But the court systems and judges just seem to still be biased toward helping women in that situation a little more than men.
Hey, I'm going to go back to Diego. He commented just now. He said, "Yes, I've been dating my girlfriend for almost 2 years now, but my daughter has not met her due to parental alienation." That's a sad one, because the only thing I could see keeping that back is if like there was something that had happened with your girlfriend. There's some reason that the kid doesn't need to be around, or there's a TPO against you or something. But I would think if it's been 2 years.
It has been, and if she's wanting it, the way he asked it before was that it was 1 year after legitimization. So if he's legitimized legally as the father, let's say tomorrow, it would be a year before he could introduce her to the child. I think that depends on the child's age. And I think if you've been dating this person for 2 years, if I'm the judge, unless mom can show me that this woman is some kind of danger to the child, I'm not going to have a problem with the child being around that person.
Right. I'd have to agree with you. We got Mr. Ben Weeble on here. He said, "Does the mother being certified paranoid schizophrenic make it easier for a biological father to get custody?"
When you file for custody, there's always several factors that the judge looks at, and I won't go through all of them. And every state is different, but all of them have a lot of the same factors. Are you financially stable? What's your home look like? Do you have room for the child? Do you have enough food? Do you have stable employment? Do you have a support system through your family to help you out? Are you spiritual at all or not spiritual? One of the factors is mental health. And when you have a custody case, you never know which one of those factors is going to be the most important. Someone may be incredibly financially stable and can provide this child with everything under the sun, but if they're not mentally stable, or they haven't had a good living arrangement, or they have some kind of drug or alcohol problem, that is what's going to take precedent in that particular case. So her paranoid schizophrenia, it sounds like she's definitely been diagnosed with that. That is not a good diagnosis. That is a dangerous diagnosis. Paranoid schizophrenics many times are the ones that, they don't take their medications, along with bipolar, they don't. That's one of the unfortunate side effects of these diagnoses. But they're the ones that go out, they harm themselves, they're dangerous to others. It depends on what level of paranoid schizophrenia she has. But yeah, if she has that certification, you definitely will want to bring that up at court.
And I know we've talked about this before, Kevin, but I've had some guy, not this ain't going at you, Ben. I'm just trying to touch down on this because it's something that we see a lot. I have somebody come to me. My ex is a narcissistic, borderline, hypomanic. They'll call them all these names in the book. And it's like, was they diagnosed as that, or is that what you're diagnosing? And we got to be careful with that, throwing that around inside a family court. And it's so common. Everybody is a narcissist now. I've had both sides of the couple come telling me both is a narcissist,
Well, that's one of the first questions when I see the other side say, the other parent saying that about my client, and we take their deposition. That's usually one of my first questions. In your petition asking for a change of custody, you stated that my client was bipolar or whatever. Do you have a diagnosis for that? What evidence do you have of that? And I will tell you 8 or 9 times out of 10, they never have anything. They've just either assumed it or thought it or whatever. But you're right. Just because someone's throwing those labels around, you better be able to prove it if you go to court, because the attorney on the other side is going to poke holes in it if you don't.
Yeah, and Ben said that was definitely a diagnosed thing, so I get that, but it's very, very common, guys. I see it all the time. He got a follow-up on here. He said, and we're trying to get custody of his sisters or are not biologically mine, but do not know their real father and have been in my care for the past 4 years. Do I have a chance to get them as well as my own son?
Ben, that's an excellent question. And that falls into what we call an in loco parentis situation. We've had that come up before on here, and it's an old Latin word, and it basically means standing in the place of a parent. It sounds like you've been a parent to those other children, even though you're not biologically their parent. You've been the father that they look up to. And you cannot forget that the child there that is biologically yours is a sibling, I believe, from what I'm reading here, of those other children. The court is going to want to know that. The courts do not like to divide up siblings. They don't like to put one here and a sister there, a brother here. They want to try to keep them together if they can. So if you have been the stable parent figure for those other children, and mom is as unstable as it's sounding like, and these are siblings of the child that you have with her, you definitely, and I'm sure your attorney's already on top of it, but that is something you want to try to pursue in court.
All right. So going back to Larchmont, Martinique's question, he said, how big does a guardian ad litem play? The investigation wasn't very exhaustive at all. Do you need me to pull up that original question, Kevin?
No, I can address this question, I think. Guardian ad litem is usually plays a very big role. It's different in every state what kind of role they play. In Arkansas, they are essentially an attorney for the child or the children. And so they speak on behalf of the children when they go to court. And the judge is going to want to hear what that ad litem's recommendation is at the end of the evidence. And many, many times, the majority of the time, the judge will go with that recommendation. Many times we get concerned about the investigation that was actually done. An ad litem has a lot of leeway that another attorney for one of the parents does not have. The ad litem can go talk to each parent without their attorneys present. They can talk to the children without anybody present. They can go talk to teachers at the school. They can go to each parent's house. They can do a lot of things to put in their investigative report. And many times that is one complaint that clients have sometimes, is they don't feel like the ad litem put in the time that was needed for their investigation.
Yeah, going back to Diego, the one they haven't allowed him, I guess, his child to see the girlfriend. He said, my daughter's mom has also requested that she personally come and inspect my home to make sure that my daughter has her own bed and room. I'm not opposed to this, but I do not want her specifically to be touring my home. What would be an alternative? Would the judge accept a video or photo?
The judge might. Another alternative is, if mom wants to do that, have your attorney request of the court. We were just talking about an ad litem. Just have an ad litem appointed for that one thing. And you might have to pay them a small amount for their time, but just have the ad litem come out to your house and then can report back to the court and say, Judge, I've looked at it. The home is fine. Now I can get that. There's some animosity there sometimes between parties, and you don't want them coming back into your house. And so that's an alternative, is having an ad litem do it.
Gotcha. Lisa came back down here about the performance bid bond, said performance bid bonds tie to our surety bonds. Attorneys at law may not be familiar with this as most are, especially California, which is like a nation of its own. So, and her original question was, are there really performance bid bonds happening behind the scenes?
I'm just not. I'm not comfortable answering it, Lisa, because I just don't know enough about any of that.
Yep. All right. Dave Murray said, what kind of punishment typically happens to an attorney or judge if ex parte communications become evident, if that becomes a factor in the ruling of the case, and who handles that? Appellate court or grievance committee?
Okay, Dave. I was listening to this question being read, and my initial thoughts were not a lot happens. And then when you got to, if that becomes a factor in the ruling of the case, I have to go to the courthouse fairly often. I'm an attorney that's in court quite a bit, and many times we have to go drop off papers or whatever, and I will see judges in passing in the hall, or may stop and ask them a general legal question that has nothing to do with any case, but we will talk to them. Now, when ex parte communications become a problem is if you're talking to a judge about a case you have with that judge and the other attorney is not present. Then there's the appearance of impropriety that you've gained some kind of advantage by doing that. The biggest part of what you're asking, and yes, there is something you can do about it, but did it become a factor in the case? What was said, and did it become a factor in the case? That is improper, especially if the attorney did it intentionally to try to gain an advantage. And if you're, there's usually it's called a different name in every state. It's not always a grievance committee. In Arkansas, it's the Judicial Conduct Committee. And then for attorneys, the committee that oversees attorneys in Arkansas is the Committee on Professional Conduct. But yeah, there are agencies that you can go to. You want to be really sure that happened and what was said, and if it really affected your case before you do anything. And as I always say, talk to your attorney about it before you do anything like that.
Yeah. All right. So give me 1 second, Kevin. Got a little bit of a long one here from Matt Eversole. He said, my ex-wife showed up to a visit with half her face black and blue. I expressed my concerns the next day on the Talking Parents app, and she told me that it happened while making a TikTok video. A couple months later, we had our mediation, and I brought it up to the mediator, and he left and asked her what happened. She then claimed it was me that did this, and then the next day filed a police report saying I waited around after a supervised visit and then chased her around in the car with my children and then caught her in a gas station and beat her up. I do have a domestic violence case from 2015, and she continues to use this case against me to keep my kids from me. The judge did not grant me some overnight visits since her allegations she made were untrue, but she kept trying to convince the judge I had a warrant for my arrest. Also, she was trying to make the judge believe I was abusing my son because he had a bruise on his butt and leg. The judge didn't buy that either. My question is, why is the judge allowing her to lie and get away with it? And am I only allowed to see my children 30 hours every other weekend?
Well, I'm hoping your case isn't over, because if these are temporary hearings you're having, then ultimately you're going to have a final hearing. And that's where your attorney can bring all of this stuff together into one narrative about what mom is doing to try to alienate you and make you look like a terrible parent that doesn't deserve more time. And you're going to be able to show all of these steps that she's taken, and that each one of them has failed. She's either lied or exaggerated what happened, and that it's all false. And you're going to have to do that, and that's going to take some legwork. If you can get a video from the convenience store where she said this happened to show that nothing happened. You can try to any witnesses you've got that were either at home when she came by and you asked her about it. And you may not have any, but start thinking about those kinds of things, how you can show that she's lying, and you're just going to have to bring those people to court. This takes me back to John Mast case, Eric, that his wife, claimed he abused her at this restaurant, And at the order of protection hearing, he did not have time to get the video from the restaurant, and so they granted it. And then a few months later, at the temporary hearing in the divorce, he did have the video, and the judge was able to watch it and put in the order, absolutely no abuse happened that night, and found her not very credible.
That was exactly what I was thinking about when I was reading it. You know, I mean, it's. I'd love to tell you that it wasn't common or it was something that was that didn't happen, but we hear about stuff like that all the time. You know,
take somebody. Don't take someone that's a hothead, but take somebody that's a friend or a spouse or something. If you're having visitation exchanges in a public place, as a witness to what's happening, you know, that may help you sometime. You can video visitation exchanges if you need to.
Yep. Brian T. Stark said, can a guardian ad litem make suggestions to teachers, coaches, etc.?
Yeah, well, yes. Normally, Brian, how they do that is they will put it in their recommendations to the court, and it'll become part of the order. So they'll say, Judge, I would suggest that the teachers, usually when an ad litem gets involved with a teacher at school, it's usually some kind of learning issue or education issue. So you might be looking at an IEP or something like that, some kind of performance plan for the child because they're struggling with an issue or whatever. Coaches are the same way. So yeah, an ad litem will make recommendations to the judge, not just on custody or visitation, but also, you know, I think Billy needs to be limited on how often he's on the Xbox. I think he needs to be outside 45 minutes a day. There's all kinds of recommendations they can make.
Yeah. When I had Red on last week, that was probably the number one topic that we talked on. We did most of the episode on guardian ad litems. For somebody that's not familiar with that, what is a guardian ad litem? What purpose do they serve? And how often do you think they're getting it right?
Well, I'll tell you for Arkansas, and guardian ad litems are really very different by state. This is one of the things where each state will have parameters on what an ad litem is supposed to do, and they're very different. In Arkansas, as I was saying earlier, they become an attorney for the child, and their job is to do an investigation and then ultimately make a recommendation to the court as to what they think on custody, visitation, and other issues. In some states, they are not considered an attorney for the child. They are a neutral person that does an investigation and then makes a recommendation, and that can be a very, very big difference. So you need to talk to your attorney in the state where you are and find out what that ad litem's actual role is. Say, what is this person supposed to be doing? And then the good follow-up question is, okay, what do I need to do? What do I need to provide to that ad litem to help my case, help show my side of things? We tell people all the time when an ad litem's appointed, we ask them to immediately make an appointment to get in there and talk to them. We had a question earlier about they felt like the investigation was lacking. If there's still time before you get to that final hearing, I will tell clients that have told me that if you think the ad litem needs to know something else, go make an appointment and go talk to them. You know, you don't want to bug them to death, but an ad litem that's doing their job should not have a problem with you making a follow-up appointment to come talk to them and say, hey, I think you missed X, Y, and Z. And, you know, I talked to Miss Robinson at the church, at the school, and you didn't talk to her. And I think it's really important that you do. And, you know, they want to know what's important to you too. These are their clients, or at least they're overseeing what should happen with these children. They want to make sure they're making a good recommendation.
Brian had a follow-up. He said, can they tell the teachers not to talk to a parent that's being alienated?
Well, I'd probably have to know more information on that. That would be, I'd have to know what's really going on there. I don't know why an ad litem, because to me, when I see that, without even the alienation part, an ad litem shouldn't be telling a teacher to stop talking to either parent. Both parents should have free access to the teachers and all school personnel. So unless something's happened, there's been some kind of an altercation or something, I don't know why that would be happening.
Guardian ad litem seem to be the controversial figure. I get a lot of questions and people asking different stuff about them. Where do you think the disconnect is coming from with these parents that are inside of family courts with those guardian ad litems?
Well, and this will kind of go to your question that I didn't answer a second ago when you asked how often do I think they get it right. There is a disconnect a lot of times, and I've been an ad litem, and I will tell you, I quit doing it because it was so dissatisfying. I really enjoyed talking to the kids and being able to try to help get them in a good situation one way or another. Every time I left court, I felt like both parents hated me. They didn't want anything to do with me. And that still happens. Both parents, even if an ad litem's kind of in their favor, they still are not happy most times with the ad litem. And the ad litems that I use the vast majority of the time, I think really care about their job and they put the effort in. One thing is I think they know I'm going to be calling and talking to them. And asking them what their thoughts are and asking them some pointed questions about some things. But the ones that I've used and end up in my cases a lot of times, I feel like they just generally do a very good job. But it's hard. If you got two equally good parents and you're having to go one way or the other, I mean, you can do a shared parenting situation, but not all the time for some reason or another. Someone's going to get more time than the other one. And whoever doesn't get more time is going to be upset about that. And, it's just kind of the lay of the land.
Now, how does that vary from state to state? Because I know you're predominantly in Arkansas, but you've practiced in other states. And we saw that Arkansas recently passed the shared parenting legislation, the 50-50, the rebuttable presumption. That's the starting point, and it can, judge still has discretion. But have you seen that process be different from somewhere like Arkansas where that's been recognized and other states where it hasn't?
Not a lot. It's so new. You mean on the shared parenting?
Yeah. It seems like to me, like Arkansas seems to get the importance of having both parents in the children's life. They passed that legislation. I was just curious, how that kind of plays into other states. Do you see it? You said a lot of the guardian ad litems are a little bit more receptive in the state of Arkansas. I was curious, like with the ones that you've worked on outside of that state, what's been your feel with that?
It has been rare that I have dealt with ad litems outside of Arkansas. Most of the time, and different. Some judges won't appoint. I mean, it's so varied what they do. And some states and then bigger metropolitan areas, they have custody evaluators. They'll have an ad litem. They'll have an attorney that's appointed for the child. They have all kinds of people involved. So, I haven't had a lot of experience with ad litems on my cases out of Arkansas.
Okay, you brought it up, so I got to ask, what about custody evaluators?
I have very rarely had one of those. I got into a case changing custody where a custody evaluator was involved before, and we were going to bring them back, but we ended up settling the case, so I never got to see how it would have turned out. But we did have a report from one in a case recently, and I won't say what the name of the case is, but we were not going to call that person as a witness. We thought the work was just wasn't. The local attorney and me did not think that the work was very good.
Yeah, I was in a discussion with a few attorneys not too long ago. They was talking about different experts when it comes to like guardian ad litems, custody evaluators. They were saying, a lot of times when these people are reading up on these cases, it seems like some of them might get preconceived notions from reading up, and it kind of stays that way. It's kind of hard to break that wall down with that preconceived notion by the time it goes into the court. I mean, have you seen any of that going on?
Yes, custody evaluators are people too. Guardian ad litems are people too. And you know how you are with certain people. You don't like them from the beginning. It's hard to move you off that mountain. And they can be biased just like anybody else.
There you go. Dave Murray said, what about in a case where they disclose evidence to one party and not the other? You got any suggestions on that? I don't think he's talking about an ad litem. I think he's talking about in general. I've heard this from a few people when they go to argue their case in front of the judge. They'll take evidence from one case and the other side doesn't get to present theirs.
you may want to follow up. I think he's asking about the ad litem gives it to one side, but not the other side. I may be wrong. The ad litems that I've dealt with are usually pretty good about providing both sides. But here's the thing. We do discovery in all of our cases. We do written discovery. There's interrogatories and requests for production of documents. And I have one of my standing requests for production of documents is give me every piece of evidence. And I put this in years ago and I've kept it, and I put it in bold and I underline it so there's no confusion. Give me every piece of tangible evidence, pictures, documents, text, whatever it may be, that you plan to use at any hearing that we have in this case. So if that ad litem has something in their hands from the other side that I don't have, then that other side made a discovery violation because they didn't give it to me. So if you can ask that up front in your discovery, that's one way you can try to prevent that from happening. And I will send interrogatories sometimes to the ad litems. You can send it to them too and say, give me all the evidence you've been provided. And they're supposed to send it to you.
Gotcha. Diego Gomez said, once we are in front of the judge with this legitimation, would the judge accept if I request that my 9-year-old daughter have a personal cell phone in which I can communicate with her directly instead of having to call the mother's phone? I ask because out of 10 calls that I make to the mother's phone trying to speak with my daughter, I only get answered on about 2 or 3.
Yes, you are right at that twilight age. A lot of people are on here and saying there is no way in hell I'm giving my 9-year-old daughter a phone. But other people, their child's had a phone since they were 7 or whatever. So every judge is going to look at that a little bit differently, but most judges are okay with some kind of communication. What I have seen with a little bit younger kids like this is they have an iPad they play on. So they will put FaceTime on there or Zoom or whatever so that they can talk to the dad. Most judges are in favor of letting the child talk directly to the other parent without the parent that's there being involved. They know that can cause problems and friction, and the kind of thing that Diego's talking about here, you call over and over and they don't answer. They say they're unavailable. This way you can have a direct link to the child and be okay with, if I were your attorney and you wanted that, I would let the judge know, look, Mr. Gomez is not going to be calling 5 times a day, Judge. He just wants to be able to have access each night to tell his daughter good night or whatever. We can put a time frame on there, a limit, how often that can happen. But no, I think it's a reasonable request.
I'm talking hypothetically here, but what's usually something like the general punishment, if at all? Parents supposed to be getting that time either through FaceTime or something like that, and mom or dad, the custodial parent, is not allowing that non-custodial parent to get that time.
Well, let's say I'll answer it this way. Let's say you came to me tomorrow morning and we talked, and you said, look, 3 times in the last year, I'm supposed to talk every day, and 3 times in the last year she didn't let me talk to him. Well, I'm going to tell you to save your money because the judge isn't going to do much about that. But if it's happened over and over and over every week for weeks on end, and it's just nonstop, this is a phone call. You shouldn't have to be getting an act of Congress to talk to your child. If the other parent is clearly frustrating that, then you need to file something and take it in front of the judge. And the judges, we've talked about contempt before. The judges, it depends on the judge and how upset with the parent they are. The first time you go, they might just say, point at them and say, no, don't do that again. And then the next time you come back, though, they might fine them. They might make them pay attorney's fees. There's lots of punishments and things they can do to get a non-complying parent in compliance.
Yeah. Another thing I've seen, man, what is the importance? So say I'm a father, I get once a week and then I get every other weekend. Talk about the importance of making sure that you're there on those visits, because I've seen it sometimes where people will pass up that one day. Maybe you had that visitation. You're pretty much destroying the argument later on of trying to go back and say, hey, I want more time with my child if you're not taking what you're being gave.
You are not pretty much destroying it. You are destroying it. When someone comes to me and says, I'm not getting my time, or I'm trying to get my time and she's not, letting me have time, and we file something, that's usually the number one response. I try to give him his time and he won't take it. He's not exercising the visitation he's supposed to have. And the truth is somewhere in there. The truth usually comes out. Now, if you come to me and say, oh no, here's all the text messages that I sent over the last several months saying I need my time. Why are you not here at 5:30 like you said you would be? They never showed up. You show me all that. Now we've got our evidence, and she's going to have a hard time countering that. But if that's on the other side, well, now we're in trouble. So yeah, if you are given a set amount of visitation, you need to exercise it, because I guarantee you, if you go back to court, she's gonna use that against you, no doubt.
Absolutely. And well, what if you were one of those parents, so you're getting that once a week or every other weekend, once a month? What are some steps that you would suggest for people to start doing in order to take that back to make a very good case to that judge? Hey, I want to get 50-50 shared parenting with my child. What are some things that the judge is going to take into consideration and that might help them in that process?
One of the things, and clients are a little disappointed when they hear this, one of the things, they'll come in to me and they'll have their new husband with them, for example, new wife, and they'll say, look, this was 3 years ago I was in court, 2 years ago I was in court, and now I've gotten married, we've got a great home, I've got my life together, I've got a great job now, I want to go back and get more time. Well, one of the things the judges look at is not what the non-custodial parent has done since you were in court last. They look at what's happened in the custodial parent's home. And if the child is still thriving, doing great in school on grades, doing great in school on behavior, extracurricular activities, seems to be a normal, happy child, it's going to be very hard to change that. It's great that you've gotten your life into a different place, but if things are going well for that child, it's going to be hard to get it changed. You have to show that substantial change in circumstances, and that this child needs to be in a little bit different schedule to make that happen. Now, as the child gets older, they may start to say, you know what, mom, or whoever is the non-custodial parent, I want to be at your house more. I want to be over here more. I want to do 50-50 time. And they may not be as happy at the other house. Then you can start to use those things to maybe build on trying to get more time.
Right.
But it's hard without that substantial change in circumstances, because the judge is thinking, I've got to think about best interest of the child. And if this child's doing great, why do I want to upset that apple cart?
Right. Yeah, that was just a few questions, and I've got a few more. One of the things that I experienced in this past week is I actually had an alienated child that wrote out to me that had seen me with one of their parents. And
wow.
it was an experience. I mean, I've had it happen a few times, but not quite like that. And obviously there was something there, because they're wanting to talk, they're wanting to know what's going on, but they're convinced, even at a young age, probably before that memory probably serves correct, because they see the paperwork and stuff. They think certain events, we won't discuss that, might have happened. And one of the things they said to me was, nobody ever looks at this through the lens of the child and what we're going through. That was hard to read, man. Mm-hmm. That was really hard to read. I mean, I'm curious if you ever had something like this happen, Kevin, and how do you talk to an alienated child if you are approached by one?
Well, I had a situation years ago, one of the last cases I had when I was acting as an ad litem, and it was a grandparent situation, and the grandparents had been essentially the parents for this child, and the parents came and took the child away, and he was very young, and he was in my office, and I was talking to him. He was just the sweetest kid, sweet boy, and we were talking about football and all this other stuff. And after a while, and he was just great and happy, and I said, is there anything about, how this goes and whatever that you would want to change? Are you happy with the way things are? Would you want to change them? And he just started bawling and said, I want to see my nanny and pappy again, and just buried his head in his hands. I mean, it was a 180-degree change. And I will never forget that for the rest of my life. The the heart pouring out of this little kid that it was very simple for him. He just wants to see his grandparents again.
That's it.
And so, yeah, those moments are incredible. And that's what you hope when you get an ad litem involved, is that ad litem's really going to listen to that child and make their wishes known. On that issue, Arkansas specifically says on the administrative order that gives the parameters for ad litems as to what they're supposed to do, it specifically says if the ad litem is going to give a recommendation that is not what the child said they wanted, they are still supposed to let the court know what the child's preference was. So if they say, I think these kids need to stay with mom, but judge, I need to let you know that they both say they want to go live with their dad. So the ad litem is supposed to let the child's wishes be known.
Right. I mean, is it a job of an ad litem if they see alienation going on? I mean, are they supposed to kind of maybe find out from the kid what's going on, or maybe to like bring them up to speed with what might be happening to them? Yes.
And I have no issue with, because the other attorney can do it too, I have no issue with reaching out to the ad litem and saying, look, this is obviously going to be biased, but this is our side of things. You can see from our pleadings kind of what we're saying. Usually the ad litem wants to see both sides' discovery and what they've gotten evidence-wise. And, I have no problem letting them know, look, we think there's alienation going on. And when you talk to these children, you may want to keep that in mind and see what you think. And many times they'll come back and say, absolutely, it's totally going on, and we're going to have to put some parameters in place to have that not happen. And other times they say, I'm not seeing it, so.
Could you imagine what it's got to be like to be inside the mind of an alienated child? They're supposed to have this loyalty to this person, their parent that's there to protect them, and they've been told things. And of course they believe that's their custodial parent. That's who they've been with for so long. They don't get to know the other side of the story. One of the first things I ask is, well, what's your relationship with the non-custodial parent's family? Well, we don't have one. I don't like any of them. Well, that's worrisome.
Very. And it's brainwashing. I mean, let's just call it what it is. It's brainwashing. And when you're with someone 24/7 and you're being told nothing but negative about the other parent, that's all you're hearing. You and I as adults, and especially since we deal with these issues, we can kind of say, there's always two sides to every story. That's a big ask for a 7-year-old to make that determination.
Yeah.
I've got mom or dad sitting there telling me all this stuff. They're my parent. I got to listen to them, so I believe it. I mean, you're asking a lot of a child that young to try to make that mental leap that, maybe mom's not so bad or dad's not so bad over there. They don't get that. So, yeah, it's tough.
And that's why we say parental alienation is child abuse.
Well, it is. And there's a judge that I think I've talked about him before on here that's not on the bench anymore. And one of the best things I would ever hear him say is he would lecture parents at the end of a case, whatever he decided. And he'd say, I want to tell you both something. When you tell that child that the other parent is bad, you're telling that child that half of them is bad. And, that child came from both of you. And you got to keep that in mind, that you're telling that child that half of him is bad when you talk about that other parent.
That's right. I've even heard Judge Judy talk about it. And Judy starting, she was speaking out about PA there at the end. And I was liking some of the stuff that she was saying. Well, yeah, we got you a question in here from Gabriel Chavez. This is a Texas related question. So Gabriel, you might have to recheck up on this, but he said, in Texas, at what age can a child say where they want to reside? And what's the process? What if there's two children involved, brother and sister, 11 and 9? I believe the average is 14, Kevin?
Well, it is, but they can't. I don't know of any states, and an attorney may be able to come on here, or somebody may be able to show me some law on it. I don't know of any state that says at a certain age, other than when you become an adult at 18, can you decide which parent you want to live with. So there's not an age. A lot of people in Arkansas think it's at 12 years old. They'll bring a child in and say, okay, he's turned 12. He wants to live with me. Let's get it done. It doesn't work that way. It's a factor. When we talked at the beginning of the show about all the custody factors a judge looks at. A child's preference is just one of the many, many factors that's looked at. And A child's age and maturity will determine how much weight the judge gives it. So a child that's 4 or 5, a judge probably isn't even going to listen to them because they're going to change. They change what TV shows they like every 30 minutes.
Yep.
But a child that's older, and Gabriel's children being 11 and 9 are getting at that age where a judge might listen to them, is going to carry more weight. And then, of course, once they become teenagers, if they come across as credible and they're not just mad at the parent for being punished or whatever, they'll give that even more weight.
Yep. And backing up what Kevin said, I looked that up. It said 12. In Texas, a child's decision cannot be the sole factor in determining which parent the child lives with. However, once the child reaches the age of 12 and upon motion, the court can consider the child's wishes as to whom she or he wants to live with. So
now let's talk about that. Now that reading, Gabriel, and obviously you want to talk to your Texas attorney, but it sounds like at 11 and 9, they cannot give a preference yet, but maybe once they turn 12, they can, by what that sounds like.
Yep. Absolutely. So check into that, my man. We got a question from Gabriela Torres. She said, question is for my husband. My 12-year-old son was given a phone by his mother, and he refuses to answer her and doesn't call her back. Will that be counted against me?
Refuses to answer her, doesn't call her back. He's 12 years old. It depends on what your last order says. If it says that you're supposed to be making sure that happens, then you could, but he's 12 years old and seeing it and just not wanting to talk to her. There may not be a lot you can do about that. I think the court would want you to be encouraging him to talk to her, especially if that's her visitation time and it's in a schedule, you need to be trying to make that happen.
Yep. Maddox Lee on YouTube said, how do you deal with a compulsive liar as the opposing party in a custody case? Is that beneficial to your case?
The second part is yes, it's absolutely beneficial to your case. The first part is you have to prove they're lying. You've got to do everything you can, text messages, emails, pics, social media, whatever you've got to show that they're lying. If they're saying that it was pouring down rain on September 24th, you're going to have to bring something in, a calendar, weather calendar or whatever, to show it wasn't raining at all that day. And is that a lot of legwork? Yes, it is. But and this is important. I think everybody needs to really hear this. Just going in and saying, no, she's lying, that's not going to work. That's judges here. He said, she said all day long. Where they really perk up and start to listen is if you have a third party come in, or you have a document, or you have a picture or a video or something off social media that supports your side of what you're saying. Now, all of a sudden, you've got the credibility. Credibility is a huge factor when you go through these cases, and you want you and your attorney to be the truth givers. You want you and your attorney to be the credibility guys. You want to be the side that's providing good information to the judge. If you're providing things that you say you're going to do and you provide this information that doesn't support it, or your client is up there consistently, all over the map and not telling the truth, the judge isn't ignoring all of that. They're catching every bit of it, and you're going to be losing the credibility battle.
Yep. It looks like Francesca Bailey might have a question, but I am not too sure. If you could re-ask that down there, I'll try to get that to Kevin real quick. We're getting near the end of the show. iTumblers on YouTube said, can a child sue a guardian ad litem in the future for purposely misrepresenting him? They are their attorney.
I suppose they could. I don't know what the statute of limitations on that would be. I will tell you, trying to show that an ad litem purposely, that's a big word. That's a major allegation. Misrepresented the child that's a high hurdle to get over. Yeah. Yep.
All right, Kevin, we're right at an hour, guys. Sorry about Monday. It was a holiday, but we will be back starting again okay, here we go. She just wrote that back in. Francesca Bailey said, hit send too soon. If the dad and biological mom has 50-50 physical custody now as of 6 months ago, and since then mom remarried and pregnant and wanting to file for sole custody since they don't want to go parent, do they have a chance?
I think she means don't want to co-parent.
Yeah.
I don't. She's going to have to show that the 50-50 arrangement just isn't working. If I'm the judge on that case and they bring that to me, I'm going to be seeing, okay, why do I need to upset the apple cart of what's going on with this child or these children? If this situation seems to be working, I think it's great that mom's remarried and pregnant and apparently happy. But if this is working for these kids, I don't see a reason to change that arrangement.
Yeah. All right. Thank you for that, Francesca, guys. Next time we'll be back next Monday and the following Monday after that, starting at 8:00 p.m. Eastern Standard Time. We welcome your questions. Get in there and ask them early. One last straggler question for tonight. Matthew Okama said, why do we have to prove accusations wrong when they have never been proven right? There's no evidence against you.
Well, that's a good question, Matthew. And clients will many times come in and hire me after the other side has filed something to either change custody or whatever. And of course, it's got all these allegations in there about how terrible a parent they are. And one of the first things I tell that client is these are accusations, these are allegations. They have to prove all of it. So the allegations are out there and they're going to say it. You've got to prove it wrong. And if they've said all this stuff, but then you bring all the evidence showing overwhelmingly that they're not true, it's going back to that credibility battle. You're going to be the one with the credibility at that point. So you have to address them because they brought it up. But if you've got your evidence together, you'll be able to refute them.
There you go. Hey, thank you for that, Matthew. Kevin, tell everybody where they can find you if they'd like to get your services, my man.
We are at www.kevinhickeylaw.com, and I have an office in Fort Smith, Arkansas, and one in Northwest Arkansas, which is in Rogers, Arkansas. Our phone number is 479-434-2414. And again, we take custody cases all over the state of Arkansas and divorce cases and civil litigation. As far as high conflict custody cases involving parental alienation, false sexual abuse allegations, those kinds of cases that are very high conflict, we take those cases all over the country. We come in and work with your local attorney as co-counsel and help you through your case.
Yeah, and for those of you that this might be your first time tuning in, I really enjoy the relationship I've had with Kevin. Met him earlier this year. You were working on the John Mast case. You were one of the ones that was in there when he got exonerated. Could you tell a little bit about that case briefly and what you did?
Well, there's a lot to it, but very briefly, yes. John, terrible case of alienation. We might ought to spend a segment someday on that case, but it's as bad as parental alienation as you can see, and including false abuse allegations. We finally got him exonerated through the family law courts. And, of course, he was going to get his unsupervised visitation when his ex-father-in-law shot him and killed him at the Visitation exchange. But I was hired by John to come in and work with his local attorney and help with a lot of those issues on parental alienation and false sexual abuse allegations. A lot of attorneys deal with custody, but they don't deal with these specific issues. And you need an attorney that understands these issues and how to attack them, and how to refute a lot of the allegations that are out there. And so I will come in and work with the local attorney to help with guiding everybody as the legal team through that process so we can win the case.
That's it, guys. I can't recommend him enough. Kevin, thank you so much for coming and taking everybody's questions tonight. We'll be back in 2 weeks. Next Monday, we'll be live with Rhett Clark and Melissa Isaac. So I guess we'll see you then.
All right. Always a pleasure.
All right, guys. Thank you for joining us tonight. We are fighting for the rights of parents worldwide. If you want to help support our podcast and for us to continue this mission, please join us at patreon.com/DadTalkToday. You will find us on Facebook, YouTube, Instagram, Twitter, CloutHub, Parler, iHeartRadio, Stitcher, Spotify, the podcast app, Google, Apple Podcasts. We're a little bit of everywhere. And guys, every time you like and subscribe, you help us continue this mission. Thank you, and we will see you next time.